Hello everyone, welcome back to LiveLaw Academy. I hope all of you are doing great. So today's discussion is related to the concept of bailment. I have a proposition for you. You apply the principles mentioned in section 148, 149, 151 and 152 of the Indian Contract Act to the said proposition and tell me what do you think whether those principles, those aspects will be applicable over here or not. Okay, let me give you the facts. Let's say you go for a fancy dinner in a five-star hotel. You give your car for parking in the valet parking and you get a receipt in return. And the receipt has mentioned that the hotel is claiming that we will not be liable. The owner is at their own risk parking the car over here. Okay, so even though they have parked it for you, they have put this owner's risk clause to exempt themselves from their liability. In such a situation, in context of that exemption clause, whether that is allowed to them. Second, whether there exists a contract between me and the hotel company or you and the hotel company because you have gone for dinner, whether any contract exists between the two of you. If yes, what is the nature of that contract? What will be the rights and duties of the parties over here? Okay, so this discussion first and foremost is related to a specific judgment. These are the facts of a case where one party goes for dinner and they lose their car. There is theft that has happened. And therefore, whether we can make the company liable or not, the hotel liable or not, right? So I'll go to the judgment. Before that, let me take you to section 148 for you to understand what are the essentials of bailment. So, just to summarize, bailment basically involves delivery of goods by one person to another for a specific purpose, right? So, here all of these essentials are getting fulfilled. What are goods are the definition is mentioned in section 2(7) of the Sale of Goods Act, which includes, of course, vehicles or cars, right? It excludes money and actionable claim, and that is a very interesting discussion that whether money can be bailed or not, okay, especially when we are talking about banks, right? So we'll do that discussion some other day. So in this situation, coming back over here, we are understanding that section 148 requires delivery of goods. Now, have I delivered my car to the hotel or to the agents of hotel or not here? So in valet parking, you give the key also to them. They park the car, they keep the key, and therefore your control is somewhat minimal, right? Versus the other situation where you are going for self-parking. You're going to the mall, you have self-parked your car, you have selected where you want to park the car, you have kept the keys with you, and now the car gets stolen. In both the situation, you have paid some amount of money, but is there any difference between the two or not? Whether there is bailment between the two or not? Whether one is an example of merely having license to use the property or not, use the place or not. Okay, these are different leg of discussion that has happened in this judgment. So let me share my screen very quickly for you to read those sections that I'm going to take you through today. Section 148 that I have already explained to you talks about the concept of bailment. 149 explains the concept of delivery. Delivery is a mandate, right? Delivery is essential. But delivery can be of two types. It can be actual or constructive delivery, wherein the threshold is assessed or the assessment is done on the basis of whether you still have control over your goods or not. So if you do not have control, you can't say that the goods are still in your possession, right? The simple concept of jurisprudence that you may have read will be applicable over here. So try reading 148 and 149 by pausing my video and then go and read 151 and 152. 151 here talks about care to be taken by the bailee. This section basically gives us that the bailee has to taken minimum care. And what is that minimum care? Care that would have been taken by a man of ordinary prudence. Nobody but a man of ordinary prudence would do reasonably in similar situation with the goods of same bulk, same quality, same value. You as a bailee are expected to do the same. Okay. So in my example, who's the bailer and who's the bailee? I, who's giving away the car, I would be the bailer, and to whom the car has been given, they would be the bailee. And therefore, 151 is talking about the care that is to be taken by the bailee, that is the hotel here in this situation. So they should have acted as ordinary prudent person. But did they really act as ordinary prudent person? Did they give away my car key to somebody, or somebody came and picked up the car key from their the receptionist? In all of these situations, can we say that 151 has not been complied with? Now, moving ahead, today's discussion is related to section 152. The idea is to understand that how this has been comprehended. I'll read 152 for you. Secondly, I'll tell you what was and how was this yellow part, this highlighted part was interpreted till 2019 when the Honorable Supreme Court decided this judgment. Okay, what does it say? It is an extension of 151. It says the bailee is not responsible for any loss, destruction, deterioration that happens to the things bailed if he has taken the amount of care mentioned in 151. So the hotel company, if they have taken care of the similar nature or as that of an ordinary prudent person, I cannot make them liable. But the catch is, in the absence of any special contract, when I would allege and I would say that they did not act as ordinary prudent person, they left the key on the reception and somebody could come and they just picked it up, or maybe somebody came and did not even show the receipt and they gave the car key to them, trusting and relying on their face. How is this ordinary prudent, how any ordinary prudent person would do this? If I allege this, they can say that, do not forget, the receipt that we gave you had an exemption clause, had an owner's risk clause, which suggested that we can, by special contract, that is the receipt, we can reduce or increase our liability. So the bailie's liability can be increased or can be reduced by special contract, of course, mutually agreed between the parties. So they can also take the protection of this highlighted part, and that is exactly what happened in our case. So the case for today's discussion is Taj Mahal Hotel versus United India Insurance Company Limited and others, which is the respondent here, the one who lost his car along with the insurance company. The judgment has layer of discussion. Okay, the judgment talks about very interesting facets. So I'll just briefly tell you about different aspects, and maybe we'll not discuss those in detail because I'm going to explain the concept of bailment here. But just to give you a slight insight, and you must read it, okay? It talks about that why strict liability should not be imposed on hotels in such a situation where the car has been lost. The basically the district, all the national district commissions, the consumer commissions at different levels were asserting on the point that we would impute the concept of strict liability on the hotel, we'll make them liable. The Honorable Supreme Court here says that no, we want to bring balance between both the parties. How do we impute strict liability here? That is a concept of 1868, which was introduced with a different insight, which was introduced with a different intention. And presently, when the hotels are, they have so many different purposes. You do not visit hotel only for staying there, only for residing purposes. Rather, you visit hotel for attending marriages, you visit hotel for conferences, for your coffee catch-ups, right? So all of these cannot always attract strict liability, and therefore that should not be applicable. Then the insurance company's locus standi was discussed, that how do they have locus here? The company claimed and the company gave an idea that yes, they do have locus in the given situation. Not just this, beyond this, a discussion happened with respect to whether they were negligent or not, because this was also, a matter of discussion under Consumer Protection Act. And then comes my discussion of bailment. As to how and whether this is bailment or not, the court here has clarified that had this been a self-parking lot where the parties have control over their vehicle, we would have not considered it to fall under the ambit of section 152. Because bailment may not really exist there. But here in this situation, bailment is attracted. And not just that, they have explained the highlighted part of section 152. So let me just share the screen now and take you to the judgment. certain parts from the judgment, not the entire judgment, but something that will tell you as to how this discussion and how this interpretation has taken place. So they've spoken about this part. In the absence of any special contract in section 152, suggests that it is open for the bailee to accept a higher standard of liability than section 151. Section 151, which says ordinary prudence, bailee can undertake a liability which is of higher degree, higher standard, but it can't be lower than the standard of ordinary prudence. It cannot be otherwise. And therefore, by a contract, you can't say that I'm exempting myself of the liability or my liability should be lesser. Even if I do negligence, even if there is misconduct, I cannot be held liable. This is a very, very important discussion with regards to reading of section 158, that part of special contract that has been done over here. Okay. In addition to this, the court has also spoken about the exemption clause, that these exemption clause, when will they be applicable? The court has said that even when there is a general exemption clause, there remains a prima facie burden of proof on the hotel to explain that when this loss or damage was caused was not on the account of negligence or want of care. So your responsibility under 151 and 152 has to be mandatorily followed. You can't really say that this, even if I have not fulfilled this minimum threshold, I can be exempted from the liability, right? The court has also spoken about that how the bailee is expected to do reasonable care. You are supposed to ensure that you do not give away the car keys without taking the receipt, right? You are supposed to ensure that all these places, your valet parking or your car is placed in a safe location, that the parking out in the outside spaces are within the vicinity of the hotel, are well guarded. The court has in fact gone on to say that it is not just that you have put guards over there, you have to actually practically prove that there was no negligence and misconduct by the guards who were really taking care or who were given the responsibility of providing such protection. Okay, so this is a discussion which has taken place in this judgment with regards to reading of section 148 to 152. In addition to that, you also get an idea as to how bailment exists in different situations. You can really practically see. So, I'll tell you why have I taken to explain this judgment. One, it has been part of your questions in your mains examination. Secondly, when I was a student, my first year of law school, when I was given a parking slip and I read the parking slip after reading contract law, this intrigued me. I was so unsure as to whether the principles of contract law will apply over here or not. How will we read this section 152 in this given situation? And this judgment of 2019 by the Honorable Supreme Court has given a very good clarity to all of these questions and at least to my doubts. So I hope you feel and I hope you have been benefited by this judgment, by the class, by the discussion today. If you have any doubts, you can please write it in the comment section. If you have any feedback, if you want me to cover any recent judgment, you can let me know about the same. Thank you so much, all of you. Have a great and wonderful day.